Thank you for joining us today. I see we've got participants getting into the Zoom as our number of participants climbs here. I'm Lisa with the Law Library, and I'm here with Kimberly Sims, attorney, and Rachel Wright, CPA, who will be our speakers today on cannabis in 2024 and beyond. And they are the dream team for this subject. They're great friends of the library. They've spoken for us on this before, but there is always something new every year, so we love to have them back. And we're so glad you joined us today. I just have a little bit of housekeeping to do before I turn it over to Kimberly and Rachel. So some of you, maybe most of you, are here hoping to get CLE credit today, and we are offering an hour of CLE credit for those of you who are verified to have attended once I get the Zoom attendance report afterwards. And that is for those of you watching live here on January 18th, 2024. You will be getting a certificate by email from me this afternoon. If you are joining us by phone, I'm only going to see a phone number on the attendance list, not your name. So when I send out the CLE certificates, if you don't get one a little later and you participated by phone, just let me know. You should have my email because I sent the handout out earlier using my email. You can just reply to that and let me know you attended by phone and need a CLE certificate with your phone number. We have had a few people doing that lately. Just wanted to let you know about that. You will be able to ask questions today. We will try to get to as many as possible. Please use the Q&A function to do that. You'll see Q&A on the screen with 2 speech bubbles, and that's where you can post questions. And again, we'll probably be holding those to the end, but we'll try to get to as many as possible. You will see a survey link at the end. Please take a few minutes to take our survey if you can, and thank you in advance for that. One last thing I wanted to mention today, I got a great question from somebody who attended a previous webinar and got our CLE attendance certificate. And of course, we use the form that the State Bar provides for that. You might be noticing that there are some new specialty CLE credit categories appearing on that attendance form, and that is causing some confusion. You will see wellness, competence, you will see civility in the profession, and you will see technology in the legal profession. And those are all new credit categories that have been approved by the State Bar. But what I wanted to say about that is even though they are appearing on the attendance certificates now, those new credit categories only apply to those of you who will be having to report in 2025. So if you are in the current compliance category reporting for this February 1st, 2024, you do not need those new credits. I just wanted to clarify that. That was a good question because those categories appearing on the attendance certificate are causing some confusion. All right, I think I've taken up enough of the time. I'm going to turn things over to Kimberly and Rachel.
Sure. So thank you so much again, Lisa, and to the San Diego Law Library for having us. This is, I believe, my 4th or 5th year, maybe even 6th year presenting for the Law Library. And I was telling Lisa before we all started that in some ways I feel like things are changing so rapidly in the cannabis space. And then at other times I feel like, at least with respect to federal law, it's the same slides every year. So I'm happy to report I do have some new information on the federal landscape to share. But again, my name is Kimberly Sims. I'm a solo practitioner and I've been practicing in this space since 2009. I work on corporate and transactional matters and regulatory compliance solely for the California cannabis industry. And as any good corporate or transactional attorney should tell you, you should always have a phenomenal CPA as your right-hand man or woman. And so I'm lucky enough to get to work with Rachel Wright on many of our, with many clients. We share many clients together, and I'll let her give a brief introduction. But during this next hour, we're going to run you through some of the most pressing and interesting and important things happening in the California cannabis landscape, as well as what's happening over in snowy DC. Rachel, do you want to do a quick intro before we jump in?
Sure, yeah. So Rachel Wright from AB Finwright and 420 CPA. My partner's been in the industry for a while as well, and I have as well, and we've seen kind of a lot of changes. Kimberly and I have been through the wars, so to speak, and the ups and downs. So if you're in the cannabis industry or looking to get in, just hang tight. That's all I can say. And that's it. Thank you so much.
Great. Okay, Rachel will be our slide master for the day. And she's also getting over a cold, so please forgive her. I told her she couldn't leave me to try and explain the tax slides on my own. So, all right, let's jump into it, Rachel. Okay, so for years now, this is a slide that I always begin my presentation with because the nomenclature and the terms of art that we use in this industry can often cause confusion from the very jump, particularly when it comes to the cannabis industry and marijuana versus hemp. These are, cannabis is a botanical term. It doesn't really actually have any legal significance. Rather, it just refers to the specific genus of a flowering plant. And the difference is how much THC a particular plant has, but the law will treat marijuana versus hemp very, very differently. So marijuana, again, is a term we've seen for a very, very, very long time, but it is for the flowering plant that has more than 0.3 delta 9 THC. And while this particular presentation is not going to get into the psychoactive effects of other cannabinoids, that is traditionally what is known to, to get people high and give them that euphoric feeling, whereas hemp has less than 0.3% THC, but it really just has to do with how long you allow a plant really to flower. But the law treats them very, very, very differently. So whenever you're working with a client and they say, I have cannabis questions, or I want to talk about starting a cannabis business, the first thing we always hone in on is, hold on, are we talking about marijuana or are we talking about hemp? So those are very different things, treated very differently. In this presentation, we're really only going to focus on marijuana. However, my practice does include clients that are cultivating hemp or manufacturing hemp products for the end user, the end user consumer. And I'm happy to answer questions about that. Please just shoot me an email if those are what your questions are about, and I can point you in the right direction as well. So let's always remember that cannabis could mean either, and we always want to know which we are actually speaking about. Next slide, please, Rachel. Okay, so this is a nice map to have. It gives a little visual here as what exactly is going on in our state. And you can see here that, you certainly don't have to count, but we have 24 states now that have legalized recreational marijuana, and 38 states plus Washington, D.C. have some sort of medical marijuana program. And what you want to do is hone in on the red, and you'll see those are states that don't have any sort of medical or recreational or adult use, sometimes we call it instead. So we are getting there. And when one looks at this map, it is, in my opinion, hard to conceive that this is still a drug that is considered federally illegal. Next slide, Rachel. For all purposes. So again, we're talking about marijuana. We're talking about 0.3% or more THC. And federal law, go ahead to the next slide, please, Rachel, treats marijuana as the most dangerous drug in terms of its schedule. And that means it has a high potential for abuse, no accepted medical use and treatment, and lacks any sort of safety. And the Controlled Substance Act basically then bans marijuana for any and all reasons. And one of the number one questions I get when I'm out and about in the world is, when do you think that marijuana is going to be federally legal? When do you think that's going to happen? And what's that going to look like? And how is that going to impact the industry? And then are we going to be able to move it across state lines? And then is everyone able to roll into Walgreens or CVS and just buy marijuana off the shelf? I mean, I think that is, I would say, Rachel, you probably agree, the number one question that we get from folks who are just dancing around the industry, who are adjacent to the industry, or just altogether interested. And for many, many years, there hasn't been a lot for me to put next on the slides. I would really say, well, there's this legislature that's floating around with this federal bill, but there's not a lot of sponsors, and I don't really know. I don't really think it's going to happen anytime soon. But I am happy to report that for the first time, I can actually speak to some actual movement, and whether or not it's a positive direction. I think the industry is pretty split on that. Next slide, Rachel. So, again, the number one question I get time and time again, even by my family members with whom I speak about my work on a regular basis is, what is the federal government doing? How is it that they're still possibly saying this should be federally illegal and listed as a Schedule I drug? So this year, in August, the U.S. Department of Health and Human Services released a statement that they believe that marijuana should be moved from Schedule I to Schedule III. And that means basically that they're drugs that have moderate potential for abuse or addiction, but that there is potentially an accepted medical use. And so you can see here, if we move marijuana to Schedule III, where it would hang out with ketamine, Tylenol with codeine, so you get a different picture of what the government is saying that it ultimately looks like. Now, this statement, this news broke in August, and then there was a lot of push to say, well, what does this research look like? What exactly did the U.S. Department of Health and Human Services say? And we first received a highly, highly redacted copy, but this week, or I guess maybe it was last week, the 12th, I believe, of January, we finally received a mostly unredacted version of the department's findings. And it basically it surveyed like 30,000 different medical professionals. I myself am still digesting it. Again, I've not had a chance to dive into 300 pages of text quite yet. It's on the to-do list, but and it said that it looked at 34 plus jurisdictions, and so we're all still digging in. But I think what's important to remember when we're talking about the federal illegality of marijuana and whether rescheduling it or removing it from the schedule altogether is ultimately the best move. I myself have always been a proponent for removing it from the schedule altogether. I believe it should be treated more closely to things like alcohol and cigarettes. And that would create a true atmosphere for federal legality and really open up a true opportunity for interstate commerce. That said, sometimes we have to take what we're given. And I believe that rescheduling is an incremental step in the right direction, because at least now we can acknowledge the medical efficacy, and it would eliminate some of the very heavy tax and banking obstacles that the industry currently faces. So I know I'm jumping ahead a little bit, but Rachel will speak about 280E. I would say it is the greatest enemy of the marijuana industry, and she'll speak a little bit about that. And because marijuana is illegal federally, the industry doesn't have access to traditional banking and lending, or things like traditional bankruptcy protections. Now, there are some attorneys who have found some ways around that. Again, that would be a completely different presentation, but it's important to know that bankruptcy, in the way that the common person would understand it, is not really available to the marijuana industry. And so the hope is that if we were to remove it to reschedule, instead of removing it from the schedule altogether, that again, we might get some incremental progress. However, it still would create an atmosphere in which it's federally illegal, and thus making the entire industry illegal at the federal level. And really, at the end of the day, it's up to the DEA what they want to do here. They have the power. And so we'll have to see. And we're going to come back to this. I think I have one more slide on the rescheduling. And And so, again, this is basically what I already said, but the Feds finally released these documents confirming that there is a new recommendation to move it to Schedule 3. And those, again, I think what my takeaway here is for everyone is the industry itself is very split on whether Schedule 3 is a good thing or a bad thing. Again, I've always been a proponent of removing it from the schedule altogether. I think that is ultimately what the industry really needs to experience success in a way that can truly create generational wealth for people, and safety for people, and erase some of the inequities that we still see in terms of enforcement of criminal laws against marijuana users and other rights of that nature. And I wouldn't be sad to see it get moved to Schedule 3. Let's move to the next slide. So I think this is where we'll start to have Rachel chime in a little bit too. I think I'm going to do a quick intro on where we are with banking. But Rachel, I don't know, real quick, sorry to put you on the spot, but what are your thoughts on Schedule 3 versus removing it from the schedule altogether?
I'm with you I think incremental change is probably the most likely. And that's, eliminating 280E also is one of the most important things to eliminate, because that is definitely crippling businesses. So obviously it makes tax returns a lot easier, and people don't have to circumvent 280E as much as they're trying to do now, and they have been trying to for the past few years. So I'd say, rescheduling is definitely a step in the right direction for sure. I know some people, I don't know much about the argument whether, Big Pharma is going to step in or not. So that's part of the fear. So I guess we'll see what happens.
Yeah. Come back next year. We'll let you know if the slides are any different on this one. All right. So, okay. So we're talking about federal law here. Ultimately, we could talk a lot about the Controlled Substance Act. We could do hours on that. But for the marijuana industry, ultimately, the two biggest impacts of the federal illegality right now have to do with banking and taxation. So, banks obviously cannot aid in money laundering or supporting potential illegal activity, and the banking industry has said for many years, many years now, that what they need is a literal act of Congress in order to feel comfortable to bank with the marijuana industry. Now, you do have some banks, smaller regional banks, that are willing to bank marijuana money. But I will tell you, in having worked with those banks, the red tape and the diligence that they need to do behind the scenes, it still makes it very, very hard for the marijuana industry to engage in commerce in the way that the rest of us do. And the fees are often astronomical, but as to be supported by the additional work that the banking and compliance teams are doing. If you have a marijuana client, I would be happy, and they're looking for banking. I know that Rachel and I have a few smaller regional banks that we have developed great relationships with, and we would be happy to work with you on giving you that information and getting you in touch with the right people. But it still makes things very, very complicated for the industry. And also, again, getting access to traditional loans is not possible. And so you have a overtaxed, cash-strapped, thin-margin industry that, if and when they want to borrow money, are basically borrowing it, mostly in hard money loan manners, or giving up insane amounts of equity in their business because of the risk factor. So we do have a teeny bit of movement in the banking update. I'll run through these slides a little bit more quickly. Rachel, the next slide, please. So this slide, truly, I have not touched since last year because, I changed it a little bit, but the leading legislation we're still hanging our hats on is SAFE, the Secure and Fair Enforcement Banking Act. And basically again, that's the act of Congress that's the legislation that the industry is saying they need to feel comfortable, truly comfortable to work with the marijuana industry. But it would prohibit federal regulators from taking punitive measures against banking institutions that provide banking services to legitimate cannabis related businesses. And so again, I think that's why you have some of the smaller banks saying, okay, we'll give it a try. And then it would establish some safe harbor provisions as well. Now, Schumer says that marijuana banking is among the Senate's 2024 priorities, but it won't be easy, you think? And then I think we must always look at the dysfunction of what is going on in Washington, D.C. to know that getting slam dunk measures passed isn't necessarily possible. And we have now a new speaker, and that is Speaker Mike Johnson, and he is very anti-marijuana. So it's not like Speaker Kevin McCarthy was, the #1 champion, but we've moved in the wrong direction on that one. Next slide, please. Rachel. So what's it gonna take is true cooperation and some resolution over some various disagreements that the two parties are having. And then we got this, really lovely survey that was released earlier this year, where 71% of Capitol Hill staff feel it's unlikely that lawmakers will pass any type of cannabis reform, including the banking legislation. And this quote at the end here, basically just says that the GOP House has become the most unproductive, dysfunctional in modern history due to its refusal to embrace bipartisanship. And this is chaos, extremism, and paralysis. And I think that can be said for some of our states trying to regulate cannabis as well, marijuana as well. So, will we see open arms banking access in 2024? Probably not. SAFE has stalled out in committee like 7 or 8 times. Every 6 months or so, you see like it gets another co-sponsor, but it is my opinion that, again, what it will take isn't going to be something like SAFE and expecting, House and the Senate to come together in some sort of grand kumbaya moment and realize, oh, wow, the issue here for lack of banking is safety. It's an unsafe industry. And then it's like, okay, but, banking would help that quite a bit. It's a very circular, like, I feel like we're on a hamster wheel here. What is obvious to us doesn't seem so obvious to some of our legislators and regulators. But again, what I really think it's going to take here is removing it to Schedule 3 or removing it from the schedule altogether. And it looks like I'm in line with 71% of Capitol Hill staff as well. Next slide. Okay, so I will go on mute now, and the esteemed Rachel will talk a little bit about how the federal income taxes continue to stifle, strangle, drown, stomp out. I don't know, Rachel, you can pick some other colorful words. The ability of the marijuana industry, not just in California, although California is very special unto itself in terms of how it's attempted to roll all this out. But it is, these are issues that the entire industry is united about, that why this issue has to be addressed head on. I will now go on mute.
Thank you, Kimberly. So those of us who have been in the industry have been dealing with 280E, the Internal Revenue Code section 280E, that's where it comes from, that eliminates essentially anything other than cost of goods sold for cannabis businesses. So those of us that have been in the industry for a while are very familiar with this. And to be honest with you, I was just on a call prior to this and with a bunch of operators, and they were talking about why it's so difficult, amidst the regulations, number one, that they have to deal with at the local level, at the state level. And then there's the dreaded 280E, which umbrellas the whole thing. And another part of the conversation was why there's an illicit market. And why is the illicit market in almost every state so big? So even in more mature markets, such as what we have here in California, the illicit market is massive. And in fact, so, even they're exporting across state lines where our, legal operators who are, have invested a lot of money in being legal, they're kind of taking it on the chin because their prices have dropped and things like that. And then on top of it, they have 280E. Now, 280E is a little misunderstood when people say that a blank slate across the board, that you can only deduct cost of goods sold. But what is cost of goods sold? And that's actually what the nuance of 280E is what is cost of goods sold? And it depends on, where you land in the vertical. So you could be a producer. A producer is a cultivator or a manufacturer. Essentially somebody that alters the state of the product in a significant way. And they're usually the cultivators and manufacturers. Sometimes they are some distributors as well. And in other states like New York, or, even here, I think some people refer to manufacturers as processors. So actually the language is changing across the country in the various states. That's what we refer to in California is cultivator, manufacturer, distributor. Those are the people who actually have the better end of 280E because they can deduct a lot of overhead costs, direct costs that have to do with producing the plant, growing it, manufacturing it. So there's a lot more flexibility with producers, but folks who are non-producers, that's what's really a lot more difficult. So say, for example, non-producer would be a distributor, somebody who I'll call it a bulk flower distributor who just takes bulk flower and resells it. They're essentially a reseller. They're not doing anything to the product whatsoever. Or a delivery service, a B2C retail service or delivery. Because they're not actually taking the product and doing anything special with it. They're usually, especially in California with the packaging regulations, they take the product, stick it on a shelf, and essentially that's it. There's no more what's called like deli style or, there's all in California, folks are not really producers that are retailers. They can't alter the product in any way. So they really do get the tough end of the 280E stick, so to speak. And in more mature markets and just in general, the people who have less that they can deduct have opted in for 471C, which is another section of the code that came out with the Tax Cuts and Jobs Act. Now, there's a lot of controversy over this, whether to take it or not to take 471C, but essentially, whichever side of the aisle you stand on, it can allow people to stay in business by taking a more aggressive tax position and essentially deducting a lot more costs than 280E would allow you to. So wherever you stand on the fence there, there's some outline here on 471C when you can actually take it, when you cannot. So if you have audited financial statements or applicable financial statements, you definitely cannot use this section. So audited financial statements, you essentially have to rely on the books and records for the client. Again, we can kind of go on and on and on about this. So I will pass. Well, let's see what we have up next. But you can see it's pretty complex. I just want to let people know it's not black and white as a lot of people think. Oh, so this next slide is me too.
Rachel, I think you're like the next 5 or 6 slides. So just
I'm the next 5 or 6 slides. Okay,
yeah,
cool.
Cozy
cool. I'm not going anywhere anytime soon. So as far as state income taxes, essentially every state you want to look at, you want to see if it actually conforms or does not conform to 280E. In other words, does it follow 280E or does it not follow 280E? And essentially in California, it allows for the normal and ordinary business deductions, which some states actually do not. So California does not conform with 280E unless you're unlicensed, actually. So remember, but most of us are not working with unlicensed businesses, I'm sure. And this is basically the same slide here, California conformity to federal tax law, but this is for corporate tax, so it does not conform for corporations. So each state actually has differences with the personal income tax and corporate. In some cases, for personal tax returns, they will actually enforce 280E or not, but each, I guess, regime, so to speak, can treat their conformance or non-conformity to 280E differently.
Hey, Rachel, I just want to jump in real quick. I'm sure it was on the other slide, but just sort of hearkening back to what we were talking about a few minutes ago with respect to whether or not we will see marijuana moved off of Schedule 1 to Schedule 2, to Schedule 3. It's important to know that when you're looking at 280E, the reason that we believe that removing it to at least to Schedule 3 would be helpful is that 280E basically, again, forbids businesses from deducting their, ordinary business expenses associated with the trafficking of a Schedule 1 or Schedule 2 substance. So I think that's why there is this sort of feeling that, again, a little bit of incremental movement here would ultimately still be beneficial to the industry because, again, of the just again the suffocation of 280E. I mean, again, imagine really not being able to deduct most of your expenses is it's nearly impossible. And we'll talk a little bit too about some of the taxes on the industry in California. I think Rachel will, or if not, we can certainly touch on it. But
yeah,
that's
sure.
Again, that's just to sort of tie those two conversations together. 280E applies to trafficking of Schedule 1 or 2, not 3.
Exactly. Yeah, so California has a couple of quote unquote tax credits that a lot of our clients actually reached out to us about last year. And unfortunately, because the hurdles are so high, it's very difficult for anybody to even be able to qualify for them. And if they do qualify, especially this tax credit, you have to apply ahead of time. And people have found it very almost impossible to qualify. So, for example, we have the High Road Cannabis Tax Credit, which started early last year, and it's going on through 2027, as is the next credit that we'll talk about. You'll find that it's very difficult for people to qualify because essentially they have to pay health insurance, 401k, and they have certain thresholds for where their wages must be. It's 150% to between 150 to 350% of the California minimum wage. And as we know, many of the smaller businesses in California, which most of the cannabis folks in California, I mean, most of them are going to be smaller, and they're definitely struggling. And so in order to kind of thread this needle of having a qualified taxpayer, they have to be paying all these different plans, the 401k plan, the health insurance plan, in between 150 to 350% of minimum wage, which, anytime I go through the qualifications of this with anybody, I feel like it's an exercise in futility because, frankly, there's almost no one that qualifies.
Yeah, how many of your clients, and then I can speak to mine, are actually setting up 401ks and providing health insurance to their employees?
So I mean, first of all, 401ks, and you could have potentially like Cal Savers or something of that nature. And I think actually Cal Savers may have been carved out. I'm not sure. But most folks don't have the 401ks because there's specific service providers that say that they do provide a 401k. but it's just not widely offered because people are barely hanging on to their businesses right now in California for the most part.
And I found too, even with some of the larger operators, like they
Mm.
just don't have the staff and administrative bandwidth to like set something like that up, even if they, if they wanted to. I will say, uh, to be honest, in terms of my clients, the only ones that are actually providing, health insurance are the ones that are required to based on collective bargaining agreements that they may have entered into. So the ones that are unionized, uh, and any cannabis business that has, I believe the threshold at present is at the state level, more than 20 employees is required to enter into a labor peace agreement, and then eventually, thought is that turns into some sort of collective bargaining agreement. So again, even and in January of next year, I believe that the state threshold drops to 10,
Mm-hmm.
10 employees. So again, the labor and the union piece of this could be a whole other seminar and topic. That is not an area that I practice in, but if there's anyone that's on this Zoom that has questions about that, I have some wonderful colleagues as well. So again, if there's something we gloss over,
Mm-hmm.
even though if it's not something that Rachel or myself can do, we have a wonderful Rolodex of amazing colleagues, and we can certainly get you in the right direction for whomever might be able to answer that question. But yeah, I just thought that's an interesting point that, how many of these operators are actually doing this, let alone whether they could qualify for some sort of tax credit. But it's just financially not feasible for many of these, even those that wish they could.
Yes, I feel like the franchise tax board, or California, was actually offering these tax credits and making it sound like they were trying to give a favor to the industry, but it's definitely a lot of lip service because there's really nobody that I know of, or very rare, that could qualify for this particular credit. And so let's see. We go to the next slide. So this is just on the same tax credit, and I don't mean to be pessimistic, but it's just is what it is. As soon as I saw these tax credits, unfortunately, a lot of folks were getting very excited, and they said, "Oh my gosh, California's offering tax credits." And then we looked at the guidelines, and they just didn't qualify. Usually, one of the main bases that they didn't qualify on, so you could see the minimum wage here. At 150% is $23.25, and then up to 350% is $54.25. So how many people are actually paying $23.25, 150% of minimum wages? Usually they're paying the very minimum that they have to, right? And then actually I'm going to go back for a second real quick, because notice that this is a type 10 retailer and a type 12 micro business. So it's not all license types either. So it's very specific license types that are allowed to take this tax credit. But if you do happen to qualify, the qualified expenditures are the wages and health insurance, childcare benefits, as you can see there. They can all go towards that credit base, safety related equipment, training services, etc. So if you do find somebody that can qualify, great. You can include all these costs in there. Okay. So the next one is the cannabis equity tax credit. And actually, remember, Kim, you and I looked at this for someone. And again, the guardrails around this, the qualifications for this are so difficult to meet that almost no one qualifies here either. So the first test you really want to look at is the gross revenue of $5 million or less a year. That's the first qualification, because anybody above that, you're not going to be able to qualify. And then you have to look to the individual criteria. And that individual has to have 50% equity ownership. So in the individual criteria is actually listed there, such as the cannabis conviction before November 2016, cannabis arrest. Now, the good thing about this is it only has to be one of the criteria. It doesn't have to be all of these. So that's very important to read, is whether it's one or all. In this case, it's only one. And then there's a household income and where you live criteria. So you can kind of fall under all of those, but in general, sometimes it's the $5 million per year, because to be honest with you, a lot of companies, if they are doing less than $5 million or per year in gross revenue, they're having a really tough time. Yeah. So, and then the tax credit for after all these hurdles is only $10,000, and you have to apply. You have to basically make sure that you apply with the DCC under the equity fee waiver program. You have to be able to qualify for that as well.
Real quick, the DCC, I'm going to get into that. That's California's governing body. That's the Department of Cannabis Control.
Thank you.
Of course.
Yes. And so again, I did not really see anybody qualifying for this either. Again, it's kind of a little bit of California lip service, in my opinion. If you found that anybody hasn't qualified for this, that would be really interesting. I'm not sure if you're able to type that in the chat or comments, but there we go. Okay, so I know a lot of us have seen, whether on Instagram or LinkedIn or just on the news in general, there's claims that the CDTFA has misled the industry in general as to what is subject to excise tax. So a lot of us may remember that last year, was it last year? Oh no, now 2 years ago, the excise tax was incumbent on the distributor. So the distributor would actually pay the excise tax.
Real quick, Rachel, I don't think maybe some of the people are on this Zoom are cannabis practitioners, but just can you quickly say like what is the California cannabis excise tax, and you know, just a quick, this would make more sense if one knew what that was.
Absolutely, absolutely.
Thank you.
So yeah, so the California excise tax is 15% tax that the distributors used to pay back in 2022, and it's only cannabis products are subject to the excise tax essentially, right? And so now in 2023, the excise tax responsibility has shifted to the retailer, and 2023 going forward. Because obviously we have to remember we're now in 2024. So
and I will say, you know, again, just looking at like the overall tax picture, right? You've got 280E hanging out in the background. Now at the state level, they're putting a 15% excise tax, which is, you know, being passed on usually to the consumer. You also have sales tax, and then you also have local taxes. So each jurisdiction can set up their own tax regime, and oftentimes they will tax at each level of the supply chain as well. So ultimately, when you get your product to the checkout line, what is it? I've heard different people say different things, but like effectively like 40+% of the purchase price, you know, you're paying taxes on. So that's another reason that it just gives a bump to the illicit market, right? If you can buy something for $50, for example, and then all of a sudden you're going to go buy that same exact product, maybe with some prettier labeling and packaging, and you're going to pay, you know, time and a half that. So the tax structure is untenable, both for the consumers as well as the businesses as well, when you think of all those different layers. And Rachel, there's a quick question in the box about ERC credits. I don't know if you want to touch on that just
sure
quickly or not as well. But I'm going to go back on.
I mean, I definitely want to get to the main crux of the CDTFA issue, because this is a big issue right now. So I think there's a lawsuit essentially against the CDTFA, and there's people maybe pursuing class action lawsuits because essentially what their regulations say is that you can carve out specific non-cannabis accessories. So for example, if you have like a vape pen, the vape has the cartridge, it has the pen, it has the battery. So the battery and the pen itself without the cartridge, which has the marijuana concentrate in it. The argument is that the non-cannabis side of things or non-marijuana side of things should not be subject to excise tax. So and that's essentially what the regulation said. But now, in light of this lawsuit, there's been some retribution, which there's discussion on that here, and we'll see kind of where that lands, but that would be huge for California retailers, and previously in 2020, the distributors to not have had to pay excise tax, which is 15% on top of for non-cannabis accessories. So we'll see how this battle ensues. It's a big battle, and a lot of operators are jumping on the bandwagon and hoping for brighter days ahead, but we'll see what happens. Now, remember that excise tax actually includes anything surrounding a cannabis transaction, supposedly. So that may also include city tax that is collected first. So it is a tax on tax on tax on tax situation. So this is going to be really important to see how this pans out. Okay, let's try to, there we go. I jumped this one in here, even though this is not tax related, but it's the FinCEN Corporate Transparency Act. I just want everybody to be aware here, and I'm sure, so this is more federal than it is state, that this is, it's definitely going to be very difficult, and people feel like it's very far reaching, that now the federal government wants to know about your entities and about all the beneficial owners. And I feel like it's definitely far reaching, but it is what it is, and we need to comply. Now, the entities that are formed this year are the ones that we're really concerned about. We have until 2025 to file any entities that were already in existence prior to this current year. There are some exemptions. So remember, there are large company exemptions. So if you're working with people over $5 million in gross revenue or over 20 employees, that is an exemption from this FinCEN corporate filing. And so one thing is that folks get kind of scared because they get into the FinCEN website, and it's Financial Crimes Enforcement Network. And so if you've ever been on that to, say, file what's called a Form 8300 for a cash transaction, it's immediately alarming to get onto this website. But remember, the penalties are very steep with these. So any entities formed within 2024, the deadline is 90 days from the date of formation, okay? And then don't forget that if there's any change in information, that needs to be updated timely as well. Otherwise, the penalties are egregious. 500 up to 500 per day. I'm sorry, 500 per day up to $10,000. So I just want to touch on that because it is such a big deal.
Yeah.
Yeah.
And I think a lot of our clients are already sort of weary of some of these government overreaches. And so I wouldn't say I'm getting pushback per se. I think when I'm alerting my clients of this requirement, they're not saying, no, we're not going to do that. But there is certainly, I would say, maybe more hemming and hawing than you might see in other industries. Many are saying like, so I'm not recognized as a lawful business. I can't, deduct taxes. And now they want this. And, my response is sort of just like, how the cookie crumbles sometimes. So that's, I think just one of the reasons we included it is, again, it shows that even though the marijuana industry is not recognized by the federal government, it still has to follow all of these rules and regulations as well. It's not exempt from having to follow those requirements.
Correct. Yeah. So I'll touch on the ERC right now. So we had a question about the ERC. So the ERC doesn't follow under the income tax regime. So the income tax regime is a different code section in the internal revenue code. So remember, we were talking about 280E and 471C. So that's under the income tax code section, and ERCs actually fall under the payroll. It's a payroll jurisdiction and payroll taxes. So it's actually a completely separate regime. And ERCs, because essentially you're paying into the system when you're paying payroll taxes and things like that. ERCs were not expressly eliminated for cannabis businesses or anything like that. So there was nothing said about that. So absolutely, cannabis businesses can file ERCs. So that is something that we do for our clients as well. And I strongly encourage it to do whatever you can to keep some of these businesses alive. So,
like whatever lifeline, right?
Yeah, whatever lifeline you can throw, that would be great. And yeah. So let's go to the next slide.
I think it's back to me. Okay, so we do only have about 10 minutes left. As always happens, I think, oh, we'll make it through with lots of time for Q&A, but there's so much to unpack really in each one of these slides. So let's just hop over to a little bit more California specific content here. Thank you, Rachel. So what we're under is the Medical and Adult Use of Marijuana Regulation and Safety Act, or we call it MAUCRSA. It has seen many different iterations over the past 5-6 years. The state began to actually regulate in a comprehensive manner starting in 2018. Prior to that, there was no state licensing structure or state body that was overseeing the marijuana industry, which obviously made it ripe for a lot of bad actors to get out there and do what they want to do. And so now again, we have the Department of Cannabis Control, which is the agency that regulates and oversees the marijuana industry. And here, different states will create different license types, but in California, we have our cultivators, our manufacturers, our distributors, who are also in charge largely for quality control and working with the testing labs to ensure that the final product is properly packaged and meets all the testing criteria, testing labs, and events. So those are our license types in California. And again, the Department of Cannabis Control is who oversees all of that. Next slide, please. And I wanted to give just honestly, I usually do things with a little bit more specificity, but I do feel like we finally have a working website here with good resources. And so, this is the website I spend, all day on usually. And you can see this is the Department of Cannabis Control's website. And if you want to click to the next slide, Rachel, I just showed a little drop-down menu. So you can kind of take a look at, what we're dealing with and what types of information is in here. So if you look, I've done the drop down for the applicants here. In the very bottom, you can see access the licensing portals. And so that's a little bit challenging because all of the licenses except cultivation are under this licensing portal, but cultivators are under a separate licensing portal. So an operator who holds multiple licenses may need to duplicate their work sometimes if you're changing your ownership, for example, or you're uploading a new diagram. You may need to do your work twice. So there is a hope. It should have happened like a year and a half ago, maybe even 2, to consolidate all these licensing portals into one. We're getting there, but it does create some redundancy for us. But again, I just wanted to give the viewers a little bit of an idea of what's on this website, because there's so much information on here, and you really can tool around here and find quite a bit. And the next slide real quick is I just wanted to show people where they could find all of the regulations. So if you look under cannabis laws, DCC regulations, and then you can click to the most current copy and text, and they're constantly doing updates. So what I would say we see the most frequent updates on are the testing, and I feel like packaging and labeling. And so that's really important, because if your product doesn't have the appropriate packaging because you missed some sort of change in packaging and labeling requirement, and then there's usually a grandfathering period. It doesn't happen right away, but if you miss it, that entire product may need to be embargoed and then destroyed. So even though I deal with these regulations every day, I still always peek at the text when I'm making a more nuanced analysis or having a more nuanced discussion with a client, because you can miss a change, and they're supposed to notice substantial changes, but what I think is substantial and what the department thinks is substantial do not always align. But again, for those of you interested in learning more, this website, really truly has a plethora of resources for you, and it's pretty functional as well for the most part, save for those multiple licensing portals. So how do we get a license? I think the most important thing that I can drive home today is that it is a dual licensing process. which means that a applicant must first obtain local approval for their marijuana business activity, and then they can receive state approval. And each and every city and county in this beautiful state has their very own set of regulations on whether or not they even allow marijuana business activity and their licensing process, and how you can change ownership. Can you transfer a license? Can you, and when by transfer, I mean to new owners, to a new entity, to a new location. Each city and county has their own unique process. Some are strictly land use. City of San Diego is strictly a land use analysis, it's a conditional use permit, whereas other cities are like Chula Vista, for example, had a very, in National City as well, a very intense merit-based application. So the cities can, it's sort of a free-for-all. They can do whatever they want. So the first thing you've got to do is make sure that you find a location and go through your local compliance, and then you can apply for a state license. And truth be told, from start to finish, you're looking at it probably about a year that it would take to obtain both. There are stringent ownership and financial interest disclosures. And I'm not going to read through this whole list here based on time, but there are a great number of documents that have to be submitted at the state level. Some of it's duplicated. You also have to have landowner and owner authorization. So you're not going to get a license until if you own the business, obviously, or the building, excuse me, that's obviously a little bit easier. But this is to say, the landlord's got to know what you're doing in the property, and you're not going to be able to sort of put like a fly-by-night operation in place. It's a very strict requirement. You cannot pass go without this landowner authorization as well, and very detailed premise diagrams and things of that nature. Next slide.
And we do have a question. Do you want to question now? Okay.
Let's see. What is this sentence?
Yeah.
So if we have time at the end, I'm happy to answer it, just because there's we have a lot of content here still, and I can stay on a little bit after one as well, and I can talk a little bit about that. But if I don't get a chance to, shoot me an email. Happy to talk about it. Go back real quick, Rachel. Sorry to the I want to do the back. Nope, you're going the wrong way, love. Wrong way. Basically, I've got here you go, with the orange and green map. I'm pointing like she could see where I'm pointing to. So I wanted, just for people to understand what the landscape looks like, is that you still have the majority of cities and counties that fully prohibit any type of commercial cannabis activity. So going out and getting a local license is not easy. And a lot of people will choose to then look for someone that already has a license and is perhaps selling it. And that, again, raises its own unique set of challenges, again, based on the local requirements for change of ownership or selling or transferring a permit. And then the state weighs in on the different types of transactions, whether they'll allow you to keep that same licensed entity or require you to start the application process from scratch. So that's a big part of our analysis in M&A deals. Next slide. So quickly, it's important to know who an owner is of a commercial cannabis business. And it's a person that has an aggregate ownership interest of 20% or more in a commercial cannabis business, and an individual who manages, directs, or controls the operations. So that's a really important one. It is subjective. I like to err on the side of caution, but typically I'll do an analysis with the client if they're like, well, does this person count as someone who manages the business, right? Or controls the operation. So that's going to be, again, sort of step-by-step analysis. But there are a lot of people that do fall under this owner umbrella, and it will require a live scan, a background check. And even if you have an entity that's going to be an owner, we can go to the next slide, Rachel. Even if you have multi-layered entities, you still need to get down to the individual. And the state does not care if you have, one entity that's owned by 10 other entities, that's owned by 3 other entities, that's owned by 2 trusts and 5 other entities. They will require you to get down to that individual. So a lot of folks thought, okay, if I'm an owner, I can sort of hide behind entities, and that's not the case here. And so I think in California and here in the US, most people understand that, but when you start to deal with some of foreign investors, they might not feel comfortable with that. They might not understand that. And so it's important to discuss with clients what type of disclosures will have to be made if they're going to enter the industry. Next slide. Now I'm zooming here. If you've got to jump, I understand everyone. Please reach out if you have other questions. And then who is a financial interest? Because that also is someone that has to be disclosed. So that's a person with an aggregate ownership interest of 20% or less, someone that's providing a loan to the business. So that's one that gets overlooked quite often. But then you have to look at the type of loan that it is, because perhaps there's a carve out as well. Or a person that's entitled to receive 10% or more of the profits of the commercial cannabis business. And so I've given a few examples there. I think it comes in to practice mostly when you're looking at IP licensing agreements. I don't know of any clients that are willing to give their landlord 10% of profits plus rent, but I suppose it could happen. But those, again, these are disclosures that are, nuanced and not something you want to mess up. Next slide, which I think I've kind of already gone over some of the, all right. So the general rule, so what's the heaviest thing that I feel like I work on is the purchase and sale of already existing licenses. That, and then just, sort of typical, B2B contracts and things of that nature. So the general rule is that licenses are not transferable or assignable to another person or owner, but you can find sort of different ways around it and structure the deal in a way that might not require you to get both a brand new local and state license. But again, you really have to look at the local rules because they vary widely. And you don't want to spend hours and hours of work and diligence. And Rachel and I have seen this happen over and over again. People come to us late in the sort of negotiations. They've worked the parties amongst themselves and they've come up with this great deal. And all of a sudden, Rachel and I say, well, hold on, here's the thing. You're stuck with this entity. You can change the ownership within the entity, but this is your entity. The locals will not allow you to start with a new entity. And maybe there's a cap on licensing. So you really are stuck. So now you've got to really open the hood and you have to see what's going on in that entity. And a lot of people go, in my opinion, much too far down the rabbit hole before coming to someone like me or one of my many esteemed colleagues to really take a look at what the local rules are. Alternatively, I've seen people set up deals where they're going to spend $500,000 to buy a local license, all for me to say, well, why wouldn't you just apply afresh here? There's no need to buy this person's license. Yes, it might take you 6 to 12 months, but buying this person's license is going to create even larger issues. And so again, you always want to start with the local rules to figure out how that deal can be structured, if it can be structured at all, right? Sometimes there isn't a value there, we realize. Next slide. Let's skip over that one because I think it's a little outdated anyway. But that just, so, what we're seeing now, I would say current day, frankly, is a lot of distressed assets, a lot of people who saw stars and rainbows and butterflies, and they now realize that this industry is not for the faint of heart. The margins aren't what they thought they were. It's not federally legal yet. They thought, okay, if we can just sort of limp along for a couple years, then we'll be able to get a traditional business loan, so on and so forth. And that's just not happening. So you're seeing quite a few, and again, these are just examples. Green Life is a cannabis business broker. I think I've got a slide. The next slide is We Can as well. You can just see, and I get emails every single day about that look just like this with lists and lists of licenses for sale. But what I will even say here is sometimes you'll look and you'll see a listing and it'll be for a city that I know, because I've worked with that city before, would not allow this type of sale. And so that's a little bit frustrating too. Now, is it the broker's job to, really dive into that diligence? That's a, conversation for another day. But it's not always as simple as these bullet points look. But if you've got a client that's interested in purchasing a cannabis business, they are out there for the buying right now. That is for sure. And then again, that's where people like Rachel and I come in to really lift up the hood, see what's going on. Is it possible? What kind of liability might you be inheriting? Does the city allow it? So on and so forth. So again, these are just a couple examples of what some of these business sales look like.
And I actually just want to say, because the liability that you may be inheriting, especially if it's a stock purchase agreement, can actually be a make or break on the situation. So you're inheriting.
And it has been for many. I think that Rachel and I have gone through a lot of transactions, and hopefully when we see the red flags, the client will listen and sort of move on. But a lot of them don't. They want to keep pushing and pursuing and seeing if there's a way to make this deal work. And as the other practitioners on this CLE know, you can only do so much for your clients and advise them on your expertise. Some are just hell bent on that particular location for some reason. And so then we do our best to outline very clearly the risks and our concerns. But again, a lot of them, I think we're sort of having like a new wave, I feel like, of people who have never been in the industry before, and they've sort of been waiting for this moment, all these operations to come online. And so they think it's like a steal of a deal. And they don't fully really understand like why there are so many that are for sale. And you see quite a few, I think, in Riverside, where in Palm Springs too. It's like a very oversaturated area. And so it's really hard to succeed on top of that. But people are like, oh, I can buy a dispensary for, $450,000. Whereas 3 years ago, that same type of business might have been like 2 or 3 million. So the value has gone down quite a bit as well. We'll see. M&A activity, some of our colleagues say, was very slow last year. Some people are predicting that it'll pick up this year. Time will tell. I'll let you guys know next year around the same time what happens in 2024. So we sort of 107. We sort of touched on this. But again, if you're going to sell, make sure your stuff is in order. Or bring someone like myself and Rachel on to help you get your ducks in a row, to be able to present yourself in the best manner possible. Be aware of the issues you bring to the table. Again, tax liability is what we are looking at most frequently. And then you really should, again, proceed as you would any other purchase or sale of a business. But again, heavy emphasis on compliance, making sure that they're compliant, because if you do a sale, right, and you transfer 100% of your equity, and let's just say city says it's okay, state's cool with the way you've structured the deal, but if there's some sort of pending, this will dovetail us into this question about disciplinary actions. If there's some sort of pending compliance issue or action, you may on paper and legally own 100% of this business, but the Department of Cannabis Control will say, we're not approving your change of ownership until you figure out this compliance action. And now you're really in bed still with this seller to try and resolve some of these issues, because nobody wants to be, on a license that they don't really have control over at the state level. And that goes for buyer or seller. So again, the diligence is so critical. And of course, in our agreements, we have exit clauses and post-closing conditions and things of that nature. But it's really hard to claw back these agreements when you see these types of things come up. And also, people often feel they're like, well, we already closed and I'm so far in it. And again, sometimes you want to say like, just walk away. It's not worth it. But people feel pot committed, a little pun and gambling pun for you. So the status of DCC, and again, please, if you've got to go, I know it's 1:10, but I do want to answer this last question. What is the status of disciplinary actions? So I would say we really are starting to see a shift where for the last few years, I feel like my clients would be inspected by the department, whether it, something brought it on or it was completely random. And then there was a lot of latitude to submit what's called a corrective action plan. You would receive a notice to comply that would list, your various violations. And then you would submit a corrective action plan, and hopefully that would be the end of it. And that it was really only like the most absolute egregious violations where you were seeing revocations. The department's goal, in my opinion, for the last several years has been very focused on helping their operators to, fix the problems and stay open and give them a chance. And I would say within the last 6 months, again, I'm just one attorney, so I can only speak to my sample size. But I think many of my colleagues would probably echo this sentiment. There's been a shift now, and we're starting to see the department have a lot less tolerance for certain violations and corrections thereof, and they're starting to revoke licenses. And there are two phases of licensing. Provisional licensing and an annual license. Now, a provisional license isn't even something that's available to a new operator today, but it is the type of license that many people hold as we sort of ramped up in the last, from 2018 to present. And again, it has a lot to do with where local governments were on their licensing and wanting to give people a chance to get their state license quickly. A provisional licensing application was shorter and easier to get. And then you have to transition to your annual. The crazy thing is, if you hold a provisional license, which by now most people shouldn't, but if you do and you are revoked, there's no appeals process. So I'm starting to see the revocation of some provisional licenses, which is devastating, obviously, to many clients who were in the process of converting, and just a lot less tolerance. And the sort of big news, I had hoped to do a slide on it, but as you can see, there was already so much content, is that the department, I think it was in the beginning of January, they temporarily suspended, I think it was something like 30 plus testing licenses for failure to meet some of the new testing criteria. And so again, we're seeing, again, I think it's a new era of enforcement, where before there was some lenience. And I think at this point, the position is, we've been doing this dance since 2018. You should know what to do. And there's still a little bit of room for correction, I think, but they're looking at businesses more closely, and I don't think there's as much latitude given. And I think with the situation with the testing licenses, and I don't know how many there are in the state overall. You can actually find that on the department's website. You can look by license type, but there aren't a ton. And so to pull back 30 of those, even if only temporarily, is very problematic. And I will say sometimes it feels like they want us to fail. It's disheartening, but many of those licensees have now, I think I read again the other day that like of those 30, 10 or 12 have come back online. They've updated their procedures. But again, it's hard because the rules are often ever changing, especially with respect to testing. And so all this is to say, there's no appeals process if you lose your provisional license. So you always want to make sure that you're helping clients move towards their annual. And if you're in a deal where it is a provisional license still, flag that as an issue to discuss with the buyer so that they understand what that means. And I'm just telling all of my clients, like, now I know you already have so much on your plate, but now is the time to get in a third-party compliance auditor. And I work with a few throughout the state, and make sure, have them come in and run through all your operations, all your standard operating procedures, because it seems to me that what we are going to see this year is less desire to allow folks to correct and more desire to revoke those licenses. So they're amping it up. That was a kind of a bummer of a note to end on. But it's wild. It's a wild industry, and I think it's not going anywhere. California is a tough one, though. It's it's definitely a very hard state to operate in. And I think we're going to start to see, we are already seeing multi-state operators perhaps say they've had enough of California and look to the East Coast and the Midwest as some of those states come online. So that's my uplifting ending.
Well, I know we gave you a
Rachel?
very, very difficult task of cramming this subject into an hour, ladies. So I really
Maybe next year
appreciate,
we'll go for a 90-minute
yeah,
one.
maybe so. I appreciate you hanging in, and for everyone who stayed to listen to
Yes,
the
thank
end,
you
thank
so
you so
much.
much. And yeah, we'll hope to see you again back yet next year. Thank you so much, and thank you
Yeah,
everyone for attending.
Thank you.
thank you.
Take
And please
care.
reach out to Rachel or I if you have other questions. We're here to help. And we love working with other attorneys and CPAs in the industry and seeing how we can support your clients as well.